My book titled Cyber Operations and International Law has just been released by Cambridge University Press. At a time when nearly half of the world population is under lockdown due to the coronavirus. The current sanitary crisis also raised important concerns in terms of cybersecurity and the use of ICTs, information and communication technologies, such as the use of ICTs by governments to monitor and track the spread of the virus and the movement of their population. Also regarding the spread of disinformation regarding the virus and the crisis. In terms of actual cybersecurity threats and incidents, we see mainly two trends. On the one hand, opportunistic cyber operations, such as the one taking advantage of the exponential increase of telework. Another example may be found in the illegitimate applications and emails offering to provide information on the virus and which are actually the vehicles for ransomwares or phishing attacks. On the other hand, there are also cyber attacks against hospitals, research centers, or health-related institutions such as the WHO. They take mainly the form of ransomware and distributed denial of service attack, DDoS attacks. These are not new, yet they are particularly worrisome in these specific circumstances. These cybersecurity threats and incidents raise numerous questions for researchers interested in cybersecurity, either from computer science, humanities, or law. What were the cybersecurity threats and incidents during this crisis, and how did they take advantages of it? Were the law enforcement and the national legislation well equipped to face these new challenges? What can we learn from this crisis, and how should we adapt our cybersecurity policy and legislation? My book is not addressing these questions, nor is it focusing on cybersecurity during sanitary crisis. Yet, the developments comprised in my book are also relevant in such circumstances. Existing international law and norms of responsible behaviors are also applicable and relevant for the cyber operation taking place during a sanitary crisis, as recently highlighted by several blog posts and articles. My book analyzed how to attribute a cyber operation to a state, what is the lawfulness of the different types of cyber operations under international law, what are the consequences of an unlawful cyber operation, and the available responses for the victims. Thus, the questions raised in my book and its findings also offer an accurate lens to study the cybersecurity threats and incidents during the coronavirus crisis. Does international law matter? That is the research question of my book. International law, and in particular the Charter of the United Nations, are the backbones of international relations and are crucial for the maintaining of international peace and security. Yet, we may wonder whether a state will consider international law as a suitable framework to address a massive cyber operation, meddling with its election, shutting down electricity for thousands of its citizens, or blowing up an industrial facility on its territory. In recent years, some states have attributed cyber operation to other states, sometimes qualifying them as wrongful acts, but without telling which rules or principle of international law had been breached, nor using the international legal framework to respond to these acts. Does this mean that international law is not suitable to address the threat associated with the exponential development of the internet and computer networks? Or is it because states are not clear on how to apply international law to cyberspace? My book addresses this question by providing an in-depth analysis of how the rules and principles of international law apply to cyber operation, as well as a deep dive into state practice. My book is comprised of an introduction, a conclusion, and 10 chapters grouped in 3 parts. The introduction provides the readers with the necessary background and demonstrates that international law is applicable to cyberspace. Thus, the rest of the book focuses on analyzing how existing rules and principles of international law apply to cyber operation, as well as on state practice on these matters. I recently designed this flowchart on the application of international law to cyber operation, which offers a perfect illustration to navigate the content of the book. When a cyber operation occurs, the first step is to determine whether it can be attributed to a state, either because it has been conducted by one of its organs or by a non-state actor on its behalf. This is what is analyzed in the first part of my book, which unpacks the question of attribution. Chapter 2 studies how to identify the computers and individuals involved in the cyber operation. Chapter 3 investigates the question related to evidence. Chapter 4, finally, focuses on the attribution of a cyber operation to a state and investigates state practice. The second step is to assess the lawfulness of the cyber operation. Cyber operations are not unlawful per se, but they may constitute unlawful conduct depending on the way they are performed and on their consequences. Chapter 5 and 6 study in which cases a cyber operation may constitute an intentionally wrongful act, demonstrating that only a very limited number of cyber operations may constitute a use of force, and that territorial sovereignty, the principle of non-intervention, and human rights constitute more relevant legal frameworks to assess the lawfulness of cyber operations. Chapter 7 investigates the circumstances that may preclude the wrongfulness of an unlawful cyber operation. In some cases, even if a cyber operation is not attributed to a state, that state may be still held responsible according to the principle of due diligence for letting its territory being used by another actor to perpetrate a cyber operation. This is the focus of Chapter 8. Finally, the last part of the book encompasses the two last steps of the flowchart. A cyber operation that is attributed to a state, that was part 1, and which constitutes an intentionally wrongful act, that was part 2, entitles the victim state to invoke the responsibility of the perpetrating state. Chapter 9 examines the law of state responsibility and how reparation may intervene. Chapter 10 investigates the measure of self-help, namely measures of retortions, countermeasure, and self-defense that may be taken by the victim state against the responsible state. Throughout its 10 chapters, my book presents and offers a legal analysis of about 20 cases of alleged state-conducted or state-sponsored cyber operation, such as Stuxnet, Babar, NotPetya, and WannaCry. On WannaCry and NotPetya, for instance, my book offers, first, an analysis of the collective attributions made by several states of these cases to North Korea and Russia. Secondly, it assesses the lawfulness of these cyber operations under international law. Finally, since both NotPetya and WannaCry were based on the Eternal Blue exploit allegedly developed by the NSA, the book wonders on the responsibility of the United States in these cases from the point of view of international law. My book is among the first of its kind to offer a comprehensive analysis of the international law applicable to cyber operation in both peacetime and wartime. This book has three main outcomes. Firstly, international law is not a panacea able to solve all issues related to cyber operations. International law may leave a victim state helpless in some circumstances. It also demonstrates that, for instance, in some cases, a state may be entitled by international law to act, but the state may lack the technical capabilities to do so, which is not a matter to be solved by international law. Secondly, it is the first book to offer a comprehensive and systematic analysis of the question of remedies. The most striking finding is that countermeasures, which are generally considered as a palliative to self-defense, should be considered as the main form of self-help against state-sponsored cyber operations. Thirdly, it demonstrates the importance of the principle of non-intervention in this context. Indeed, cyberspace offers to state many new possibilities to intervene in the affairs of other states. In that sense, numerous cases of alleged state-sponsored cyber operations studied in the book, if not the majority, constitute unlawful interventions under international law. I hope you found this virtual book presentation interesting and that it triggered or reinforced your interest for the international law applicable to cyber operations and for my book. The book is available on the website of Cambridge University Press and Cambridge Core. The links are available in the description of the video. The flowchart used to present the content of the book has been published in both English and French. The references and link to the publication are also available in the description of this video.